senior judge of the High Court of Madhya Pradesh, who is also member of the General Council of National Law University, National Law Institute, University, Bhopal, Justice Vishal Dhagat, Justice Purushendra Kaurav, former judge of Madhya Pradesh High Court and now judge of Delhi High Court, Justice Rajendra Menon, former Chief Justice of Delhi High Court and presently Chairman of the Armed Forces Tribunal, Justice Shantanu Khemkar, former Judge of the High Court of Madhya Pradesh and Chairman State Consumer Forum here, Justice Ajit Singh, my former Chief Justice of the Guwahati High Court, Sri Satyendra Singh, Lokayukta MP, Sri Narendra Pratap Singh, Upalokayukta MP, the Principal District and Session Judge, Bhopal, judicial officers who are present here, Professor Dr. S. Surya Prakash, Vice Chancellor of the National Law Institute, University, Bhopal, Senior Professor Dr. Gayur Alam, faculty members, family members of Justice G.P. Singh, and my dear students. A very good afternoon to all of you present here today. For me, it is indeed a matter of great honor and privilege to deliver today's lecture as part of Justice G.P. Singh's Memorial Lecture Series. As a young lawyer in 1990s, the two most prized possessions in my chamber and which were gifted to me by my father were D.D. Basu's Constitution of India and Justice G.P. Singh's Principles of Statutory Interpretation. It is through this book that I got introduced, like many others, to the brilliant legal mind of Justice G.P. Singh. This book remained one of my prized possessions till Justice Ajit Singh, my Chief Justice, presented me with an updated version of the book, where the foreword was written by Ajay Singh and Justice Ajit Singh. The G.P. Singh that I knew from a reading of the book soon transformed into a more familiar figure as the good-natured Chief Justice made me, my wife Sanghamitra, and my daughter Shweta a part of the family. I distinctly remember Justice Ajit Singh is very famous of, is very fond of non-vegetarian food. So it so happened that biryani used to come from Hyderabad. That tradition still continues. Recently we had again biryani from Hyderabad. Justice Singh said, I will keep the mutton biryani with me, you take the chicken biryani home. And the Chief Justice's residence there is very picturesque. It is on the bank of the river. And Justice Singh developed a habit of dictating judgments on the bank of the river. Anyway, Nirja Singh, whom we fondly called with respect Nirja ma'am, her affection and kindness also endeared her and the family to all of us. Soon, Jagat and Vaishnavi. At that point of time, Aditi had not yet joined the family, became part of our family. Through Chief Justice Ajit Singh, we also came in close contact with Ajit Dada, his elder brother and Bhabiji. There is a reference to Bhabiji in one of the forewords of Justice Ajit Singh, when she requested him to about this, I think Ratanlal Dhirajilan's law of torts. I think she was a member of the State Consumer Disputes Redressal Forum. I distinctly remember on one or two occasions during our visits to Bhopal, when we had met them, we shared meals together. Much after Chief Justice Ajit Singh left Guwahati on demitting office, in a family get-together, my younger sister, who is an ophthalmologist, told me that recently she had met Dr. Harsha Bhattacharya. Those who come from that part of the country will recollect or remember Dr. Harsha is one of the outstanding ophthalmologists of this country. He is presently with the Shankar Netralaya at Guwahati, who told her that he had an occasion to visit the High Court and met the Chief Justice. In the course of their conversation, he said, the Chief Justice mentioned about me and told Dr. Harsha that I was the best judge in Guwahati. On hearing this, I was a young judge then. I felt very happy and also vindicated. It bolstered my confidence. I also fondly recollect that Justice Ajit Singh frequently used to tell me and many others that my judgments used to remind him of his father's judgments. A great compliment indeed. To be compared to the legendary judgments of the legendary G.P. Singh is indeed a great compliment. It goes without saying that such words of appreciation from your Chief Justice is really inspirational, and it did inspire me. As I matured into my judgeship, I started heading division benches in Guwahati, then in Mumbai, and then in Hyderabad. In each of these three places, I tried to pass on whatever little I knew to my bench partners. Today, as I look back, it gives me immense satisfaction whenever I come across good judgments authored by my colleagues who had shared the bench with me and who acknowledges that in one way or the other, I had mentored them. As I look back today, I do think that Chief Justice Ajit Singh did try to pass on one message or the other to me, particularly when I was heading the bench dealing with issues of citizenship. There's a very peculiar issue out there. There's a dedicated bench which deals with citizenship, which is a very sensitive issue there. For whatever reason, I could not properly comprehend at that point of time the message that he was trying to pass on to me. Recently, in our summer vacation, we had gone to London, and coming to know of my visit there, some professors from Queen Mary University, which is an important university, they said, "Sir, why don't you come over for a cup of tea and we'll have a frank discussion?" So I said, if you want to have a frank discussion, then please make it a closed event, no recording, because back home there will be a lot of criticism. Though I am a part of the Supreme Court, I am an insider. I am critical of the functioning of the Supreme Court to a great extent, and I don't mince my words. Perhaps for this reason, some are not happy, but we leave it at that. In that interaction with the Queen Mary University's students, researchers, and teachers, I said, they asked me, "Sir, what do you think? Do you have any regrets? What is it?" I said, I have completed about 16 years of judgeship now. Jokingly, I said, for a judge, the first 5 years, he is very unsure. He doesn't know. He thinks whether his orders passed are correct or not, he's very unsure. Next 5 years, he becomes overconfident. He thinks every order passed by him is correct. Next 5 years, he becomes totally indifferent. Right, wrong, he will pass orders. So this is the fate of a judge. But that apart, I said, as I look back today, I won't say wrong. Many of my decisions, whether on the administrative side or on the judicial side, would have been done in a different way. Same thing, if those are given to me now, I would certainly do it. I would have certainly done in a different thing. Perhaps that was the message Justice Ajit Singh wanted to pass on to me, but for whatever reason, I could not properly comprehend at that point of time. We leave it at that. All that can be said is that Chief Justice Ajit Singh had a very successful tenure of more than 2 years, and during that period, the High Court gelled as one family, thanks to the collective leadership that he encouraged. The High Court did really well, and this was acknowledged nationally by the Supreme Court, several judges of the Supreme Court. One incident I would like to mention, we are all out of Guwahati now, would like to mention, is about the wedding reception of Dhagat and Aditi at Jabalpur. At that time, I was the Chief Justice at Hyderabad. The wedding was on a weekday and was at Orcha. So there were communication problems with it. Therefore, it was not possible for us to travel from Hyderabad all this way during a working day. But the reception was fixed on, subject to correction, February 16, 2023. 16th February? Oh, you have forgotten. All right. Which was a Saturday. So we decided to come, myself and my wife. But it so happened that by virtue of my office, I was the Chancellor of Nalsar, University of Law. much earlier, we had decided that we should have the convocation, but we left it. We decided that we should have the Chief Justice of India be the convocation speaker. So we requested the then CGI, Justice D.Y. Chandrachud, so please come and deliver the convocation address. He said, my office will let you know. It so happened that he chose February 16 as the convocation day, that he would come to Hyderabad and deliver the convocation address. So we were in a great dilemma, what to do. We had to come and attend the reception, then the convocation was there. And as the Chief Justice, as the Chancellor of Nalsar, if I am not there to welcome the dignitaries, what will happen? The Chief Justice of India and two senior judges of the Supreme Court, they arrived. Justice Ram Subramaniam and Justice P.S. Narasimha, they arrived at Hyderabad. In the meanwhile, I had checked, and I found that there was an 8-hour flight from Hyderabad to Jabalpur at 4:30 in the evening, and it returns back the next day around 8 o'clock in the morning. We took our chance and booked our flight tickets. CGI and his group came, Hyderabad. Convocations, luckily for us, convocation started on time at 11 o'clock. And by the time we had lunch together, it was 2 o'clock over. And the CGI and his team decided that we'll go to Sri Sailam to visit the temple there, and that he would come back the next morning. So the moment CGI and his team left for Sri Sailam, we rushed to the airport, took the flight from Hyderabad to Jabalpur. We reached around 6:30, attended the wedding reception. Next day, early morning, we went back to Hyderabad and was ready at the hotel by 10:30 to welcome the CGI back from on way back from Sri Sailam. Today, as I look back, I feel a sense of fulfillment at the success of our adventure. But I shudder to think as to what would have happened if the flight from Jabalpur to Hyderabad had got cancelled or had got delayed. So these are the imponderables of life. Sometimes it clicks, sometimes it does not. In life, so also in law. So thank you, Justice Ajit Singh and the family, for your kindness and warmth in inviting us to this beautiful city of lakes and to this green campus of NLIU, Bhopal. Justice Guru Prasanna Singh was of India's most distinguished judges and jurists. He served as the 8th Chief Justice of Madhya Pradesh High Court from 1978 to 1984. During this period, he also briefly discharged functions of acting governor of MP on 2 occasions, in 1981 and in 1983. Even after demitting office, he continued to contribute to the administration of justice as the chairman of the Madhya Pradesh Law Commission and later as a Lokayukt of Madhya Pradesh. Born on January 3, 1922 at Raipur Karchulian village in Rewa district, Justice Singh received his early education at the Central Hindu School, Benares. He pursued his higher education in the Benares Hindu University, where he obtained his Master of Science in 1941, securing the first position. He subsequently obtained his law degree from the same university in 1944. After his enrollment in 1954, in between he was a lecturer, Justice Singh began his legal practice before the Rewa Judicial Commissioner's Court, when he also served as a lecturer in the Government Law College. Following reorganization of the states and establishment of the Madhya Pradesh High Court, he shifted his practice to Jabalpur. On November 7, 1967, he was appointed as an additional judge and later on as permanent judge on July 29, 1968. As has been pointed out by Justice Dhagat and the Vice Chancellor, apart from his judicial career, Justice Singh made an enduring contribution to Indian legal scholarship through his seminal work, Principles of Statutory Interpretation, which remains one of the most authoritative and widely cited treatises on statutory interpretation in India. In fact, the name of Justice G.P. Singh has become synonymous with statutory interpretation with this book. It so happened when I had gone to Bangalore a couple of years back to meet Justice U.L. Bhatt, who was my Chief Justice then, who also was a Chief Justice here. In the course of our conversation, he asked me, who is your Chief Justice now? I said, Justice Ajit Singh. Then he said, oh, the son of that, he was searching for the name, maybe because of his old age. That's statutory, principles of statutory interpretation, and I said, G.P. Singh's son. So G.P. Singh became synonymous with this book, even now. He has also edited with great finesse Ratan Lal and Dhiraj Lal's The Law of Torts. I have with me a copy of the updated 26th edition of this book, possibly the last time Justice G.P. Singh edited this 8th book. Justice Singh had built a formidable reputation of authoring clear and structured judgments. Justice A.K. Patnaik, former judge of the Supreme Court of India, writes, Justice G.P. Singh's judgments are of high quality. Though shorn of any verbose or unnecessary quotations and are straight on the point. Mr. P.P. Rao, senior advocate, while recollecting the contributions of the Madhya Pradesh High Court to the development of law, referred to Justice G.P. Singh with great deference and said that his judgments are known for their quality and precision and are worthy of emulation by others. Therefore, it is not surprising that a book has been published titled Justice G.P. Singh Select Judgments, a tribute to his craft, method, and style, published by LexisNexis, Buttersworth, Vadhua, Nagpur, with a foreword by Justice A.K. Patnaik. Justice G.P. Singh passed away on 5th October 2013, leaving behind a lasting legacy as a judge of unimpeachable integrity, a jurist of exceptional caliber, legal scholarship, and an unwavering commitment to judicial independence. He is widely regarded as one of India's finest judges, who most unfortunately was not elevated to the Indian Supreme Court. There are reasons which are there. It won't be, I won't like to go into those reasons today. But one thing is clear. It is not only Justice G.P. Singh. Such omissions continue to plague the Indian Supreme Court even today. This is another topic we will discuss some other day, not today. Justice Markandeya Kajju has described Justice G.P. Singh in the following words, and I quote, "One of the legendary judges in India was Justice G.P. Singh. He was a judge of the highest integrity and principles, and was also profoundly learned. His book, Principles of Statutory Interpretation, is still regarded a classic. He was senior of Justice J.S. Verma, who later became the Chief Justice of India. Justice G.P. Singh deserved to be made a Supreme Court judge by any standard. This sentiment is widely echoed and shared. George Gadbois Jr., who was the research guide of Abhinav Chandrachud, in his book, Judges of the Supreme Court of India, also acknowledged Justice G.P. Singh's professional reputation. He said Justice G.P. Singh had an excellent reputation, but he had run afoul of the government, in particular by refusing to accept certain government nominees for judgeship. This trend continues till date. On this occasion, I pay my respectful homage and tribute to this exceptionally principled, independent, and scholarly judge whose contribution to Indian jurisprudence extends well beyond the bench. Before I start my oration, a word or two about this university. This is my first visit to the university. In a span of over 25 years, this university has established itself as a center of learning and excellence. It has done commendably well, for which the faculty and the students deserve all the praise. But one word I would like to put in. This university has done exceptionally well. There are many universities which are doing well. The question is, where do the Indian universities stand today on a global comparison? Why is it that people with means, the first thing they do is to send their students, as to send their children abroad? Why? We need to ask this. The other day, I was invited by another national law university to the induction program of the new batch of students. I requested the university that allow the students to be themselves, encourage their inquisitiveness. Students should be encouraged to question. Unless students question, they will only be parroting the texts, and they will become like a captive audience. Captive audience, I say, when a High Court judge speaks, the district judges are there, the district judiciary, the judges from the trial judiciary are there, and they dare not question. Everything is being asked, or everything being said is being lapped up. So our students need to be critical, need to question, including the judiciary. Judgments, after being delivered, are required to be critically examined and criticized if necessary. Criticism of a judgment does not amount to criticism of a judge. Recently, on an arbitration conference, I was there in Delhi High Court. I said about one of the recent judgments of the Supreme Court in Delhi Metro. I said about this. I said this judgment has sent shock waves in the international community. arbitrators and those investors. As if taking a cue from this judgment, the government of the finance ministry has issued a circular saying that above 10 crores, no arbitration. ONGC, Oil India, they have followed suit. No arbitration beyond 10 crores. Delhi PWD has said, henceforth, no arbitration, go to civil court. When we have a statute, Arbitration and Conciliation Act, when the Prime Minister says that our objective is to make India a global hub of arbitration, to make ease of doing business great in India. Now, how can we expect people to come to India for arbitration when you have erratic court judgments and such regressive government policies? The law minister, way back in 2016, had said, I go to Singapore Arbitration Center, I go to Hong Kong Arbitration Center, I see parties are Indians, the subject matter of dispute is Indian, the two lawyers are Indian, two sets of lawyers are Indian. Why are they going to Singapore? Why are they going to Hong Kong? Mr. Law Minister, this is the reason. Who will come here? 34 petition in Delhi High Court takes about 3-4 years. Bombay, it takes 5 years. These are the two major high courts there, insofar as arbitration is concerned. Then we have 37, 136, review, then occasional curative jurisdiction. So these are the issues our students need to question the judgments. The recent judgments, for example, EWS judgment, the economically weaker section judgment, needs to be critically examined. There are people say there are fundamental, I'm saying as a student of law, there are fundamental flaws in this judgment. It needs to be analyzed. The judgment needs to be. Unless we do that, how do we improve? If everybody goes and tells the judges, sir, wonderful judgment. Sir, what you say is excellent. Sir, you are a jurist. Then nothing, how will the system improve? So that is why I say our universities should have that much of autonomy, at least academic autonomy, to explore or venture into uncharted territory. I told the students, you are young people, you have a free mind, think it that way. Palestine, India has recognized Palestine. We have a Palestinian embassy in India. Traditionally, India has always recognized Palestine. The recent incidents in Gaza, for example, it is South Africa who has moved the International Court of Justice against what is happening there, saying that please make a declaration that it's a genocide. Justice Bulldozer of the Delhi High Court, former Chief Justice of Orissa, UN appointed him as the chairman of a committee to go into this violence in Gaza. He has published a report which is accepted by the UN. It is now in the public domain about the violence meted out by the state on such children and women, elderly people, sick people in Gaza. These are issues. I'm not saying that only these issues should be debated. These are the issues which should agitate the young mind of a student, of a research scholar. You must read, you must question. That is the place of a university. And I found it very amusing when in Bombay, Shivaji Park, a group of people wanted to demonstrate in solidarity with the people of Gaza. The permission was not granted by the government. So they moved it in the Bombay High Court. The learned judge said, don't you have any issues in India? Why do you have to go that far to agitate? It's really very, very amusing to say the least on this. So therefore, friends, I urge upon the university community to allow this critical aspect of a student instead of, because I'm saying this because I'm told one of the NLUs had taken punitive action against a student for asking questions. Universities should be seen as encouraging students to engage in debate, to engage in uncomfortable questions. Comfortable question, everybody can ask, everybody can answer. These uncomfortable questions, and not seen as curbing or stifling such voices. Having said that, the preface actually took a bit of quite a long time. Let me come to the topic of my oration today. I will be very short here. It is state, courts, and the citizens. Before I dwell on the functioning of the courts and the expectations of the citizens from the courts, let me briefly touch upon the doctrine of separation of powers. Justice Dhagat has said that, which is a foundational principle in almost all democratic societies worldwide, including India. This principle ensures that the three branches of the state, we all know, legislature, executive, and the judiciary, are clearly demarcated, thus preventing any one organ of the state from having unbridled and unchecked power. This framework is essential to uphold the rule of law by ensuring an effective system of checks and balances. Historically, this doctrine was conceptualized as a response to autocratic rule, where the monarchs exercised absolute power. The Greek philosopher and polymath Aristotle, in his book, The Politics, noted that a functional state comprises three critical elements. First, one that deliberates on public issues, the second that oversees administration, and the third that adjudicates disputes. This is Aristotle in BC. John Locke, the famous English philosopher, also known as the father of liberalism, made a substantial contribution to this doctrine. In his book, Two Treatises of Government, it is 1690, he advocated for the separation of legislative and executive powers, emphasizing that distinct governance rules help safeguard civil liberties and prevent authoritarianism. This doctrine gained momentum after Montesquieu, a French judge and political philosopher, articulated the theory of separation of powers in his landmark book, The Spirit of Laws, in the year 1748. He coined the phrase trias politica, which also means checks and balances between three branches of the government. An example of trias politica is that of a three-legged stool, where each leg represents a particular organ of the state, that is legislature, executive, and the judiciary. Thus, a three-legged stool would remain strong and effective if all the three legs remain strong independently. If there is asymmetry in alignment, there is the danger of the stool falling apart. The three are placed at equidistance. If we have two legs at one place, the stool will fall apart. It will fall down. This is the fundamental principle. Therefore, when a former Chief Justice of India says, I am going to the Rajya Sabha to bridge the gap between judiciary and the executive, it is fundamentally wrong. It is completely wrong fundamentally. It goes against the principle of separation of powers. There's a fundamental fallacy there. As articulated by Montesquieu, in that spirit of laws, the doctrine of separation of powers is crucial for safeguarding the rule of law and the freedom of the citizens, because he was of the view that there can be no liberty where the legislative and the executive powers coalesces in the same person. Globally, countries have adopted varying degrees of separation tailored to their conditions and historical context. In the case of India, the doctrine of separation of powers is not enshrined explicitly in the Constitution, as in the United States, where the doctrine is a clear-cut structural element of governance. Instead, India adopts a more fluid and flexible approach influenced by British constitutional principles, which do not advocate for a strict watertight separation, but rather a system of checks and balances. This approach has led to a unique implementation of the separation doctrine, characterized by significant overlap and interaction amongst the three branches of governance. However, the Constitution provides that in matters of interstate disputes or disputes between the three organs of the state, or the interpretation of constitutional principles, the final say will be that of the Supreme Court. Therefore, the position of the Supreme Court is unique. While maintaining the federal and institutional balance, the Supreme Court has an edge in as much as it is the final arbiter, and by virtue of Article 141, its decisions are binding on one and all in the country. Therefore, the Supreme Court is the guardian of the Constitution and the Republic. It is the sentinel on the qui vive. Friends, I am not competent. Rather, it would be inappropriate for me, as a sitting judge of the Supreme Court, to comment on the functioning of the legislature and the executive. Therefore, I would refrain from doing so. However, I can certainly say a word or two about the judiciary, its functioning, and the expectations of the citizens from the Indian judiciary, more particularly the Supreme Court of India. Of course, keeping in mind my limitations. Friends, let me turn a few pages back in history. We go back and forth. The Guwahati High Court, of which Justice Ajit Singh was the Chief Justice, was initially established as the Assam High Court. It was the first High Court of independent India. Ironically, the first Chief Justice of the first High Court of independent India was an Englishman, Sir Ronald Francis Lodge. If you read Fali Nariman's autobiography, Before Memory Fades, you will find a brief reference to this in the book. Inaugural function was held on 5th April 1948. Sir Harilal Kania, the then Chief Justice of the Federal Court, presided over the function and delivered a widely reported speech. In that speech, he not only broke a tradition of judicial reticence, but importantly, he highlighted the need for judicial independence, which perhaps he felt constrained as a member of the colonial judiciary. Chief Justice Kanya's speech was one of several public and private initiatives by the Indian judges to shape the contours of the draft constitution that was then being debated in the Constituent Assembly. Archival materials show that almost all sitting judges, whether in the High Courts or in the Federal Court, actively pushed for changes in the draft constitution, highlighting the need for an autonomous judiciary. Upon reading portions of the draft constitution, Chief Justice Ramlal of the East Punjab High Court got so visibly agitated that he wrote directly to Pandit Jawaharlal Nehru, expressing his concerns about certain provisions dealing with the judiciary, which he thought had the potential to undermine the independence of the judiciary. Nehru forwarded it to the Constituent Assembly Secretariat. Perhaps anticipating a flood of such correspondences, the Secretariat officially invited all High Court judges to submit their views on the draft constitution. Close to 100 High Court judges offered individual feedbacks, while some of the High Courts additionally offered collective statements. The judges, collectively and individually, stressed upon the need for judicial autonomy, uncompromised by the power of a popularly elected executive. Justice Shiude of the Nagpur High Court, Nagpur has now become a bench of the Bombay High Court, very lyrically he wrote that the executive in a democratic state was bound to be a fluctuating body. Like the clouds, it may come, it may go. Therefore, the executive should not be allowed to exert its influence over the judiciary by arrogating the power to control it. Supreme Court's coming into existence coincided with the coming into force of the Constitution of India. It had its first sitting with all the 6 judges in attendance then on 28 January 1950, 2 days after India became a republic. During the inaugural sitting, Justice Kania, as the first Chief Justice of India, delivered a speech outlining the broad contours of the Supreme Court. He emphasized 3 essential principles for the Supreme Court. First, he stressed the importance of an independent judiciary, asserting that Supreme Court must operate independently of the legislative and the executive branches. Second, he highlighted the need for a flexible judicial approach to adjudication, which is not fixated with the textual content. In other words, Supreme Court should interpret the Constitution not as a rigid set of rules, but as a living entity. Lastly, and most importantly, he said, the Supreme Court must earn the respect of the citizens to establish itself as a legitimate institution. This foundational vision, highlighted by Chief Justice Kania, signifies that Supreme Court was meant to be more than a legal body, as it is to serve as the moral compass and the constitutional conscience of the nation. By insisting on independence, it ensures that the judiciary can check misuse of power by the legislature and by the executive, safeguarding democracy and individual rights. The call for a flexible, evolving interpretation means that the Constitution would remain relevant to changing societal needs, allowing the judiciary to drive progressive reforms. Finally, the emphasis on earning public respect underscores that judicial power relies not just on law, but on trust and legitimacy, making accountability, integrity, and transparency essential for the judiciary to function effectively in a democratic society. Friends, it has been more than 75 years since the Supreme Court started functioning. During this long period, several important and path-breaking judgments have been delivered by the Supreme Court. I am not going to refer to all those judgments. Justice Dhagat has already referred to quite a few of the judgments, so I'm not going to refer to all those judgments. I only take the liberty to mention about one judgment, which I think is the most important case, and that is the case of Keshavananda Bharati. A 13-judge bench of the Supreme Court, the highest so far, laid down a simple but a significant constitutional principle that the Constitution of India has certain essential features which form its basic structure. The majority held that by exercising the power of amending the Constitution under Article 368, any provision of the Constitution can be amended. That power the Parliament has got. But in the process of amendment, the basic structure of the Constitution cannot be altered. There is a history to this. I will not go into all this. Shankari Prasad, Sajan Singh, then Goloknath, then this Keshavananda Bharati, followed by Minerva Mills, and so on and so forth. This judgment has stood the test of time. It has been applied more than a dozen times by the constitution benches of the Supreme Court. So it is wrong when the then Vice President of India questions the jurisprudential legitimacy of the judgment. It is wrong. It has stood the test of time. It is also wrong when a former Chief Justice of India asserts in the Rajya Sabha that I am not very sure of the jurisprudential foundation of this judgment. This judgment has stood the test of time. And the essence of this judgment is the Constitution cannot be used to mutilate and destroy itself. That is the essence of this judgment. You cannot use the Constitution and to destroy itself. The learned judges, after mentioning certain features as essential features forming the basic structure, however, did not foreclose the list of basic structure. They kept the list open-ended. But they listed out something, and which was followed by other judgments: rule of law, independence of the judiciary, judicial review, separation of powers, federalism, democracy, periodic elections, etc., have been read, interpreted, and held as forming the basic structure of the Constitution. Though it is the constitutional duty of all the three organs of the state to uphold the Constitution by ensuring that the basic structure of the Constitution does not suffer any assault, ultimately it is for the judiciary, and more particularly the Supreme Court, to ensure that these essential features are protected. I ask myself, if the judges do not protect independence of the judiciary, who else will protect? If the judges do not enforce the rule of law, who else will? Today, we find many people taking law into their own hands, making hate speeches, doing this, doing that, with impunity. Why is it? We need to ask ourselves. The judges need to ask themselves. Coming back to the basic structure doctrine, I have to mention about a distinguished German jurist, Dietrich Conrad. Conrad was the head of the law department in the University of Heidelberg. Recently, in the vacation, we had the good fortune of visiting this town of Heidelberg, which is very near to Frankfurt. This university is of 1386 vintage, mind you, 1386 vintage, this university. Subject to correction, it has produced 54 Nobel laureates. That is the question. I go back. Why Indian universities are not producing academics and scholars of this repute? Where have we gone wrong? So Professor Conrad, he came to India on an invitation and he visited the Banaras Hindu University, Law Department of Banaras Hindu University. In February 1965, he delivered a speech. In that lecture, Professor Conrad spoke about the implied limitations of the amending power of a constitution by giving extreme examples, such as he asked, could a constitutional amendment be passed abolishing Article 31 or abolishing the constitution altogether and reintroducing British rule? Is it possible? Obviously, these were extreme and patently unreasonable illustrations. But these extraordinary exhortations made the larger point that there ought to be limitations on all powers exercised by the institutions, including the amending power, and there ought to be checks and balances to ensure such limitations. Therefore, we go back to the doctrine of separation of powers. Therefore, we go back to the example of the stool with 3 legs. If there is asymmetry in the 3 legs, the stool will collapse. Conrad's fundamental conclusion was any amending body organized within a constitutional scheme setup cannot in its very structure change the fundamental pillars supporting the constitutional authority. It cannot. In his lecture, Professor Conrad referred to Germany's Weimar Constitution. It's very important. And explained how Hitler came to power using the emergency provisions of that very constitution so that the constitution could be used to destroy itself. And when Hitler did this, as the chancellor, when he hollowed out the constitution of Germany, the German courts remained silent. Either they look this way, look the other way around. Some say they actively participated in such mutilation. I'm reminded of this movie, Valkyrie, I think. Valkyrie is the movie, yes. During the war, some within the German armed forces thought that we had enough of all this. It's time we get rid of this person. But the mission failed. This is how the movie, of course, it's a movie that has to be some natural exaggerations. And all of them were captured. But that's not the issue. The issue is, there's a scene which shows a German judge. The way he reacted to these people, it showed as if he would take the gun and he will shoot them himself. This was the state of the German judiciary at that point of time. And this was what Professor Conrad had in mind when he emphasized on the doctrine of basic structure, saying that do whatever you feel like, the essential features of the Constitution cannot be changed. This is the essence of the judgment. Friends, I won't take much longer. We all know that the judiciary has neither the purse nor the sword. The only thing that the judiciary has and which sustains it is the fate of the people. This is what Chief Justice Kania had said when he spoke about legitimacy. For the judges and the judiciary to remain legitimate and to remain relevant, public perception is most crucial. It amazes me when we go on ourselves patting our own backs by saying how powerful the Indian Supreme Court is. How great Indian Supreme Court is. Undoubtedly, it's a great institution. Generations of judges have built brick by brick to build this great institution. But it is not for us to make that comment. It is for the citizens to assess. Perception of the citizens as to where the judiciary stands today, more particularly the Supreme Court, 75 years after we have become a republic, is what matters. On November 18, 2024, I attended a roundtable conference at the Constitutional Club, New Delhi. It was organized by Mr. Kailash Satyarthi and his Bachpan Bachao Andolan. Satyarthi wants to bring in an element of what he calls the compassionate quotient in justice delivery. So a roundtable discussion was held on the topic, role of compassion in achieving justice for all. A number of sitting and retired judges were present in that conference. About 5-6 retired judges, about 10 sitting Supreme Court judges were present, including Justice Gawai and myself. As I was listening to them, I was asking myself as to what could be the reason for having such a conference. Is it because there is a public perception that somewhere down the line, the courts or the judges are no longer seen as sensitive or compassionate or responsive towards the people? In that conference, when my turn came, I praised the bulldozer judgment of Justice Gawai, forbidding demolition of houses and premises by using bulldozers. But I said, it's a good judgment, no doubt, but it has come 2 years too late. It should have come 2 years earlier. You may also ask, what is the impact of this judgment? I would say practically nil, zero. With virtually zero impunity, residential houses and small business premises are being demolished by using the might of a bulldozer. In Pune, I had spoken about this, and I said, when you use a bulldozer, it is like bulldozing your constitution. It's like bulldozing over your constitution. In that conference, I spoke about the need for judicial introspection. I had said, only if we introspect, we will be able to see or find out our shortcomings. I asked myself, I asked the group there, could the Supreme Court have done better regarding the migrant workers during the pandemic? Could it have done better during those testing times? We need to have a candid conversation on this. We need to find out our shortcomings or where we had gone wrong. it is only then there can be course correction. Building up on this, in my judgment in Wikimedia Foundation versus ANI Media, I said that for the improvement of any system, and that includes the judiciary, introspection is the key. That can happen only if there is a robust debate, even on issues which are before the court. Both the judiciary and the media are the foundational pillars of democracy, which is a basic feature of our constitution. For a liberal democracy to thrive, both must supplement each other. Friends, it will not be an exaggeration. I will not comment on any contemporary happenings in the country. I'll refrain from doing so. But it will not be an exaggeration to say that public space for expressing divergent opinion is shrinking in India. The right to express one's views and to demonstrate peacefully are fundamental freedoms of the citizens. Debate and dissent are the essence of democracy. Unfortunately, even normal activities are being criminalized. People who come to voice their anguish over environmental degradation, which is a reality, are chased away as if they are criminals. Students protesting in campuses are arrested and they do not get bail for 30-40 days. They are suspended, for which they have to go to the court. It takes time. These issues raise serious questions. Citizens are finding that though the courts are responsive and do grant bail, do grant relief, many a times it is belated. But it is the restrictive conditions which are imposed while granting bail that are causing the greatest concern. By such restrictive orders, are the courts indirectly telling the citizens or discouraging the citizens not to express their dissent? It is not confined to any particular case. Take, for example, the case of a group of youngsters breaking their fast over the river Ganga by consuming chicken biryani. I'm sure consuming chicken biryani is not an offense, can't be an offense. There is no law prohibiting consumption of chicken over the Ganga river. They were arrested for that reason, very reason. And they had to remain in jail for three months. 3 months. Can you imagine? It took 3 months for the courts to grant them bail. Can people be arrested and denied bail for 3 months for such an activity? I ask myself. Citizens are watching. The world is watching what is happening. For putting up a post on Facebook, commenting on the conduct of a minister who had called a serving Indian Army officer daughter of a terrorist only because of her fate. An FIR is lodged. He had to seek anticipatory bail. Anticipatory bail is granted by the court, no doubt about it. It's granted. But what does the court do? Deposit your passport. Hurry, it's not a flight risk. Deposit your passport. Don't post any other your Facebook post or attend any public meeting or give speeches on this regard. Take the case of young student activists who had suffered long incarceration. While the court granted them bail, they were directed not only to surrender their passports, but also not to participate or address any public meeting, whether in physical form or virtually. Imposition of such restrictive conditions severely undermine their fundamental freedoms and liberty. People would be justified in asking as to whether by passing such orders or by imposing such restrictive conditions, is the court also sending a message that do not participate in such public activity? The Supreme Court Bar Association, they had a conclave in Bangalore this March on various issues confronting the courts and the lawyers. I was also invited, and I was also part of that conclave. Myself and my wife, we took out some time from the conclave and visited Justice Venkat Chalaya, who resides in Bangalore. I believe Justice Venkat Chalaya is one of the last surviving great Chief Justice that India had. We had a very cordial discussion on various topics concerning the judiciary. At the end of our conversation, both of us agreed he's 30 years senior to me. Both of us agreed that the present generation of judges it is for the present generation of judges to uphold the Constitution and its constitutional spirit. If they cannot add to that, or if they cannot carry forward the good work done by the previous generation of great judges, at least we should not undo the great work done thus far. Friends, this is where we stand today. You may find my oration a little bit depressing, but I am an eternal optimist. I have great faith in the young lawyers of this country. I am inspired by the young and vibrant law students of our country. From my interaction with them, I can certainly vouch for the fact that the new generation of lawyers and law students, who are future generation of lawyers, are far more committed to the rule of law and to the Constitution than my generation was. That much I can say. I see great hope in them. And I'm sure it is they who will ensure that Indian courts do not deviate from the foundational vision of Chief Justice Kania. There are vast majority of people who believe in the judiciary. There are hard-working judges, whether at the trial courts, at the district court, at the high courts. They work day and night. They are hardworking. They have no godfathers. It is through their good work that Indian judiciary has survived 75 years. I believe it is through the good work of these judges, the unheard of judges, the unspoken judges, the collective initiative of the citizens, lawyers, and the law students, which will ensure that the Indian judiciary retains its relevance. Thank you very much, and God bless.